Welcome to Tales from the Chancery, a YouTube channel and podcast that aims to bring the wonders of medieval law to you. The legal records of medieval England are a truly wondrous thing. On average, English men and women in the 1400s brought approximately 5 times as many lawsuits per capita as modern Britons. So much for modern compensation culture. And the medieval English were fanatical about legal procedure and assiduous record keepers. The 4 central law courts were held at Westminster Hall. Highlighted in blue on the left is Westminster Hall, which was situated within the Palace of Westminster. To the north you can see King Street, which is now called Whitehall. To the west, Westminster Abbey and Westminster School. On the opposite bank in purple is Lambeth Palace, the palace of the Archbishop of Canterbury. The scribes and clerks of the 4 courts were so conscientious in keeping records that we have over 1 million case records from the 1400s that have survived to the modern day. In scope, they're like a library of Alexandria for medieval English life, and like 2 million cuneiform tablets that have been recovered from Mesopotamia, covering everything from grain manifests to customer complaints, letters, spells, poems, descriptions of labour disputes. There are unfortunately far more tablets than there are people who are capable of reading them. But for the geekiest researcher, the medieval legal records are something to luxuriate in, thumbing through cases and reading stories of people who, in many cases, will only appear in recorded history once, that is, in their lawsuit. The central law courts were held within the cavernous Westminster Hall. The Court of King's Bench, Common Pleas and Chancery was set up on wooden platforms, with the King's Bench and Chancery sharing opposite sides of the southern end of the hall, and Common Pleas set up 2/3 of the way up the western wall, closer to the northern entrance. The Court of Exchequer was in a small side building, and it was also the location of the Court of Exchequer Chamber, which was a paramount court of appeal in which all the justices of England would gather en banc to decide complex legal issues. The hall would have been a very busy and noisy place. People would jostle to get to the front, to the bar of the court, and you didn't have a particular time assigned for a hearing. The court sat from 8 AM to 11 AM Monday to Saturday, and getting there early and having a good relationship with the clerks was the best bet for having your case heard in a timely way. Due to this chaos, and also the problematic nature of medieval transport, from the date your hearing was due to be heard, you had 3 more days on which it might be called, either due to your non-attendance or the schedule of the court. During winter it would have been a cold and draughty place, warmed only by a few coal braziers in the corners. No wonder the justices wore their full ermine robes every day. Here are 2 of the only 4 illustrations we have of medieval English courts. So on the left is the Court of King's Bench. This was the most senior of the 4 courts, with primary jurisdiction over pleas between the Crown and the subject, and also supervisory jurisdiction over lower courts, which they exercised through appeals known as writs of error. By this time, the King's Bench was also exercising a civil jurisdiction as well. At the top you can see justices in their red robes. Not much has changed there in terms of judicial garb in the last 600 years. Beneath them, at the table of green cloth, are the clerks, officers, and prothenotaries of the court. They are recording entries for the plea rolls in Latin, and a court reporter is recording law reports in Law French, a kind of bastard legal Anglo-Norman. Strangely enough, the oral language of the court was English, at least from the mid-1300s. On the left of the picture you can see law students crowding in to watch proceedings, for the observation of legal proceedings was considered to be one of the most important ways law students could learn the practice of law. Below that you can see the bar of the court. You can identify the 2 barristers as they are wearing coifs, or a fitted wool cap on their head. As is clear, the garb of the medieval barrister was much funkier than it is today. The party-coloured blue and green is very dashing, in my opinion. And at the bottom, a number of miserable-looking prisoners, for the King's Bench did exercise a criminal jurisdiction. On the right-hand side of the screen, there's the Court of Common Pleas. This was the court that saw the most business, up to 10,000 cases a year in the 1400s. Only sergeants at law, which were medieval QCs, and who are identifiable by the coif, they're known as the Order of the Coif, were technically permitted rights of audience in the Court of Common Pleas. The Common Pleas' primary jurisdiction was over pleas between subjects, and especially over real actions, or lawsuits involving the ownership and use of land. Given the importance of land ownership in medieval England, you can understand why it saw the most business. You can see sergeants crowding around the bar of the court. It was not unusual for sergeants whose cases were not yet called to nonetheless interject ideas and thoughts during legal argument, and there was a very free exchange of views and arguments between the justices and the sergeants. Justices and sergeants were generally considered to be a single class, and becoming a sergeant almost always meant you were marked to become a justice. The next two courts are the Courts of Exeter and the Court of Chancery. The judges in the Court of Exeter were called Barons of the Exchequer, although this does not mean that they were members of the peerage. The Chief Baron is in red, and as you can see, they all have quite funky judicial garb. The Exchequer was a tax court, but it could also admit civil cases. If you owed taxes to the king and another subject owed money to you, you could bring case into the Exchequer as a debtor of the king and proceed against that defendant, so that if you succeeded in getting a judgment, the money could be transferred to the king. As is evident from the picture, the clerks of the court are counting their gold coins, and at the bottom of the picture is an unfortunate man in a wooden cage. Evidently, he didn't pay his taxes. On the right is the Court of Chancery. The Court of Chancery didn't deal in the ordinary common law, but in a legal framework known as equity. Its emphasis was on fairness, on remedying unfair outcomes that might occur due to gaps in the common law. If your case was one that could be brought in the common law courts, the Chancery typically wouldn't take it on. One of the biggest advantages of Chancery is that you didn't have to bring a claim with a writ. To commence proceedings in medieval England, you had to purchase a writ from the Government Department of Chancery. That is, there were two Chanceries, the Court of Chancery and the Government Department of Chancery. The departmental chancery was where you would pay to have a writ issued. You would pay the fee, and their scribes would engross the details into a formal written Latin, seal it, and deposit it with the court. This could be expensive. In Chancery, you would commence proceedings with what was called a bill. That was simply a piece of paper, written in English, setting out your complaint. The Lord Chancellor and the Master of the Rolls, the clerks of the Chancery, who were judges of the court, tended to be clerics and men of the church, as you can see by their haircuts. Chancery bills tend to be some of the most interesting cases in medieval law because they eschew the completely formulaic language of the common law courts and provide much more flavour and texture. And now to give you an example of a case. Today I'll recite a single case to you, but there'll be more in future episodes. Medieval London was a bustling and exciting city. It was called the City of 100 Churches. It was filled with churches, merchant guild halls, inns, taverns, dockyards, prisons. It had its own city government, whose ancient liberties were protected by the Magna Carta. The city government was elected by members of the various guilds, such as the goldsmiths, grocers, fishmongers, salters, haberdashers, but there was also an uglier underbelly, a criminal milieu within London. In the 1450s, many of these people were unemployed ex-soldiers from the 100 Years' War in France, and hence starts our case. This is the case of Neville and Walker. It starts with the formulaic introduction. To the most worshipful and reverend Father in God, the Cardinal Archbishop of York, Chancellor of England. It continues, meekly beseecheth your poor beadwoman, Agnes Neville. Beadwoman means something akin to prayer woman, but in this context, essentially it means plaintive. Your poor beadwoman, Agnes Neville, that whereon one Thomas Walker, soldier, late coming out of Normandy, at the robbing of the house of Philip Malpas, come in the high street, being acquainted with your said beadwoman, and bringing in his hands 3 dishes of silver, as he now saith, and his arms full of cloth. And he delivered the said dishes to your said beadwoman, charging her to keep them for him, the which dishes your said beadwoman, being feared of her life, received, and forthwith, then and there, other misruled people, in the sight of the said Thomas, took away the said dishes from your said beadwoman, And that notwithstanding, the said Thomas hath taken an action of detenue against your said maid woman, upon the which she is arrested, and is in prison in London, she having 3 young children, and her husband being in the king's service in Normandy, to her utter undoing. Please it therefore to your most gracious lordship, the premises tenderly considered, to grant a corpus cum causa, to bring the said maid woman before your good grace, and to rule the premises as saith and conscience shall require, for the love of God, and in the way of charity. So what is happening here? Agnes says she was standing in the High Street minding her own business when Mr. Walker, fresh from robbing the Malpas household, handed her 3 stolen dishes and told her to hang on to them. Then, in his sight, another group of people took the dishes from her. Mr. Walker has then, through an action of detenue, which is a claim for property like a bailment tort, sued Agnes for the dishes. It is interesting that Agnes's husband is a soldier in the wars serving in Normandy, as is Mr. Walker. In medieval law, having the attendance of both parties was considered absolutely vital, and so even in a civil case, the defendant would be arrested to ensure their attendance, unless they could put up surety for bail. It seems Agnes could not. Her husband is away, she has 3 young children. One does also wonder whether the entire thing was a scam, that the people who took the dishes were actually working for Mr. Walker all along, and he always intended to sue for the detenue to extort money from her. In any case, Agnes asked for a corpus cum causa, or a habeas corpus, to bring up her body, as it were, to the Court of Chancery and decide the case on the merits and equities of the situation. A major frustration of the Chancery records is that, unlike our records for the other courts, we have a lot of Chancery bills or claims, but very few documents outlining the results and outcomes. For Agnes Neville, she appears in the historical record but once and fades into history, never to be heard from again. Such is the case and the frustrations of researching many medieval cases, but they nonetheless provide a fascinating insight into medieval life, and also into the fascinating legal system of medieval England, which I would assert was one of the most procedurally fair of any medieval kingdom. So that's it for today, short and sweet. I apologise for the poor audio and production values. Hopefully these will improve as I become more skilled. I need to provide attribution to Stevius42 for providing the sound effects of medieval London, and the AGAS map provided by the Museum of Early Modern London. Other than asking for the usual like, subscribe and press the bell, I'd ask you to consider donating to the crowdfunder for the judicial review of PD 51ZC. This new practice direction is creating a pilot program in which judges will be able to decide claims without ever seeing the parties in person, with no trial whatsoever, and simply adjudicate on the papers, as it is known. This is completely alien to our legal traditions. As I mentioned, in medieval England the attendance of the parties was considered vital. In order to get a default judgment, you had to bring 5 consecutive writs that called for the person to appear, and then gradually seize their property into the king's hands, then their lands, and only after declaring them outlaw could you get a default judgment. The attendance of both parties was considered indispensable to justice, and so it is today. It's notable to me that this pilot is being imposed on the small claims list, against those in society for whom a £2,000 case could mean a lot, and that it's being piloted in Bedford, Luton, Guildford, Manchester, Staines, and Cardiff. You can draw your own conclusions there. I'll put a link in the description to the fundraiser. I hope you've enjoyed this episode. In the next episode I'll get to more cases and have more about the medieval legal profession in the City of London. I thought it was necessary to provide some basic introduction to the legal system. Until next time.